Welcome to the fourth video of this model. In this video, we will focus on the second core crime in the jurisdiction of international criminal courts and tribunals: crimes against humanity. The difference between crimes against humanity and genocide is that genocide targets specific groups. Crimes against humanity are attacks on civilian populations that are at risk because of their presence in the targeted population. But what makes a crime against humanity? By whom can they be committed? Can large-scale attacks by non-state actors constitute crimes against humanity? These are the questions that we address in this video. We will first discuss various normative theories to explain the concept of crimes against humanity. Then we will explore its context and the offences included. The origins of crimes against humanity can be found in the humanitarian principles governing armed conflict. The crime was codified for the first time in the Charter of the Nuremberg Tribunal. Under traditional international law, the conduct of a state versus its own citizens was a matter of internal affairs. The inclusion of crimes against humanity in the Nuremberg Charter therefore marked a significant development of the concept in international law. Crimes against humanity are not codified in a universal treaty. The crime was, however, included in the statutes of the major international criminal courts and tribunals because of its recognition under customary international law. The statute of the International Criminal Court contains the most comprehensive treaty codification. It lists certain prohibited acts such as murder, extermination, enslavement, or sexual violence. They qualify as a crime against humanity if they're committed as part of a widespread or systematic attack directed against any civilian population with the knowledge of the attack. There are various normative theories to explain the concept of crimes against humanity. The first one is laws of humanity. According to this theory, crimes against humanity are international crimes because they present an attack on both humanity and the quality of the individual as human being. A second theory relies on the link to international peace and security. It argues that crimes against humanity are international offences since they threaten the peace, security and well-being of the world. This justification is reflected in the Nuremberg and ICTY definitions. The third theory relates the essence of crimes against humanity to the right of individuals to be protected from abuse of state power. In other words, crimes against humanity are banned because they are the result of a state policy that promotes or tolerates such crimes. This theory grounds crimes against humanity in human rights. It finds some expression in the ICC statute, which contains an express reference to a state or organizational policy. But the view that crimes against humanity are exclusively tied to a state policy disregards the threats posed by powerful non-state actors. It would imply that an entity such as ISIS, which does not formally constitute a state under international law, cannot commit a crime against humanity. This result has been rejected by the jurisprudence of the ad hoc tribunals and the ICC. Today, it is widely recognized that organizations with de facto control over territories ought to be equated with the state. Most judicial decisions even go a step further. They argue that protection also applies in relation to the actions of non-state actors that are capable of committing a widespread or systematic attack, irrespective of a nexus to a state. It is thus the functional capacity of the entity, its organization and its effects that are decisive, rather than its nature as a state entity. This means that non-state actors can commit crimes against humanity. The essential element that distinguishes crimes against humanity from domestic crimes is their context. They must be committed as part of a widespread or systematic attack against the civilian population. The notion of attack is understood in a wide sense. it includes not only the use of armed force, but also any form of mistreatment, including denunciation or discriminatory practices. The ad hoc tribunals have made it clear that the civilian population must be the primary object of the attack. Legal attacks on combatants are thus excluded from the scope of crimes against humanity. An attack is widespread if it is conducted on a large scale and causes a large number of victims. There's no specific numerical threshold. International criminal courts and tribunals typically look at factors such as the consequences of the attack upon the targeted population and the number of victims. Systematic refers to the organized nature of the acts of violence, such as the repetition of similar criminal conduct on a regular basis. It can be shown by the existence of a plan involving attacks or other indicators, like the existence of a particular policy or ideology to destroy or weaken a community, discriminatory measures such as discriminatory law, measures changing the demography of the population, or the involvement of high-level political or military leaders in the establishment of the plan. The contextual elements need to be assessed on a case-by-case basis. This poses difficult questions of assessment. For instance, large-scale terrorist attacks, such as the 9/11 attacks or the Paris attacks, might satisfy the criteria due to their systematic nature and indiscriminate focus. But it is sometimes difficult to determine where crimes against humanity start and where they end. Crimes against humanity consist of two types of offences. The first type is a so-called murder type. Some, but not all of the murder type offences are also criminal offences in national legal systems. They include murder, extermination, enslavement, deportation or forcible transfer of population, torture, sexual offences, and enforced disappearance of persons. The second type of offences is persecution related. These crimes are not always criminalized or even prohibited in national legal systems. They are typically geared at the persecution of a specific group of people on racial, religious, or political grounds. The existing crime definition captures many modern types of violations. For instance, enslavement captures certain forms of modern slavery and human trafficking. Torture has been recognized as a crime irrespective of state involvement. Moreover, sexual and gender-related crimes have been developed in an unprecedented fashion. The list of crimes is not exhaustive. This allows the investigation and prosecution of other inhumane acts that do not neatly fall under any of the other existing categories. In this video, we've discussed the normative theories of the concept of crimes against humanity and some of its dynamic features. We've seen that the scope of crimes against humanity has been considerably extended beyond its traditional origin by international criminal courts and tribunals. It covers attacks by non-state actors. It also enables courts and tribunals to capture modern forms of violations that have not been prohibited in specific treaties. In the next video, we will focus on our final core crime, war crimes. I hope to see you there.